name is Dr. Jay Chotel, and I am a professor of special education at George Washington University and a member of the Lynn faculty team. For the next two sessions, I have put together some materials that focus on the responsibility of the educational establishment to provide a free, appropriate public education for students with disabilities. My focus will be on the young child with disabilities, and the materials will highlight the differences in responsibility for children 0 to 3, preschoolers, and the identified school-age population that qualifies for special education and related services under the law. This introduction will highlight some of the things that I believe are important in the decisions that are made regarding service delivery in the public system. It will also highlight the evolution of those mandates from the initial court cases of the early 70s to the first focused legislative initiative, 94-142, passed in 1975, to the reauthorization legislation that was passed in 2004. There have been bumps along the way, but there is no question that the expectations regarding service delivery, achievement, and inclusive services have brought significant change to how we serve our children with disabilities and their families. By way of a quick overview, IDEA had 4 original purposes: to confer on students the right to an education, to protect parents and students' rights, to assist state and local education agencies in the delivery of appropriate services, and to assess the effectiveness of those services. Recent controversies caused Congress to amend IDEA in 2004. These involve student discipline, resolution of disputes between schools and parents, and the dependency model that many thought was the direct result of the earlier versions of the Education of the Handicapped Act. The theory of the new morbidity also influenced Congress in 2004. There is clear evidence compiled by the National Research Council in 2002 that disability is positively correlated with a person's family structure, racial, ethnic, or linguistic background, particularly non-Anglo, non-English speaking, socioeconomic status, poverty and poor education, and place of residence, particularly urban and rural. The positive correlation between disability and any one or more of these 4 other factors is known as the theory of the new morbidity. Disability will exist in tandem with other disadvantaging factors. This fact is called comorbidity, the simultaneous existence of more than one disadvantaging factor. This has led to a series of exclusionary and inclusionary criteria for evaluating a student into or out of special education. In essence, these factors cannot be the primary cause for disability, and these factors may make it seem like a child has a disability when they do not. This fact has caused significant change and when and how we serve students who may be eventually identified as having a disability. This unit will serve to explore those issues in a fair bit of detail. IDEA is a grant-in-aid statute and also implements the 14th Amendment of the Constitution. It has 4 parts. Part A consists of findings of fact and statements of purposes and policies, as well as definitions. Part B relates to the education of students ages 3 through 21. Part C relates to the education of infants and toddlers birth to 3. And Part D relates to national, state, and local capacity development. Let me talk for a minute about the principle of dual accommodation. IDEA, NCLB, and the anti-discrimination statutes relate to each other and together create the principle of dual accommodations. More about that in a minute, but first you need to remember that IDEA has 6 principles: 0 reject, non-discriminatory evaluation, appropriate education, least restrictive environment or placement, procedural due process, and parent participation. Each of these principles will be discussed in turn with a focus on the first 4 principles and a roadmap for appropriate procedures in the case of the last 2. How do the principles for NCLB relate to the above? How can we transition from the IDEA principles to the more generic requirements of NCLB? We will focus on the similarities, inconsistencies, and differences in the two laws in greater detail in the readings that follow. NCLB has 6 basic principles as well: accountability, highly qualified teachers, scientifically based intervention or evidence-based intervention, local flexibility, school safety, and parent participation and choice. IDEA, NCLB, and the anti-discrimination statutes relate to each other and together create the principle of dual accommodations, that you must build the student's capacity and at the same time change the agency's behaviors and build their capacities as well. And now to the 2 units that I've created for you. A good portion of the content has been adapted from the work of Ann and Rutherford Turnbull from the University of Kansas, whose book in this area is now in its 7th edition. The work is infused with both content and empathy for the population, as their son, who had a moderate disability, became to some extent the motivation for their work. I hope you find the materials both interesting and valuable. Enjoy.